contract for deed is a popular type of seller financing for buyers who perhaps can't qualify for traditional bank loan financing currently, but plan to be able to qualify in the future. So under a contract for deed, a buyer makes payments to the seller monthly for a set period of time, after which there's a balloon payment at the end. If the buyer performs, the seller gives the buyer a deed at the end, and the buyer legally owns the property. So it's attractive to buyers who, again, are perhaps repairing their credit and plan to be able to qualify in the future, but can't qualify right now for a mortgage or a loan through a bank. And it's attractive to sellers who have found a buyer and don't mind receiving monthly payments for a set period of time. Risks are if the buyer can't perform or otherwise defaults, then the seller can cancel the contract, evict the buyer, and resell the property. And if that happens, the buyer loses its investment in the property. So it's important that if you're going to do a contract for deed, you get an appraisal of the property to see what you're buying and what it's worth. It's also important to check the property records, see if there's any liens on the property, and make sure the seller actually owns the property that they're selling. And finally, make sure that you can actually afford what you're buying, because if you default or you can't make that balloon payment in the future, you're going to lose your entire investment in the property. So transfer on death deed, or TOD as the acronym goes, is a relatively new way to transfer ownership of real estate in Minnesota. TODs are analogous to beneficiary designations on bank accounts or other financial accounts that you may have seen. Essentially, the owner of real estate designates a beneficiary who will receive the property upon the original owner's death. During the owner's lifetime, the owner maintains full property rights in the real estate, and the beneficiary's rights only mature upon the death of the original owner. TODs have been really popular for parents who want to leave their real estate to their children, want their children to avoid probate, but want to maintain ownership of the property during the parent's lifetime. So upon the owner's death, the beneficiary will receive whatever interest the original owner had in the property, subject of course to any mortgages, liens, judgments, encumbrances. For the TOD to be valid, it must be recorded in the county where the real estate is located, and most importantly, it must be recorded before the death of the original owner. So when people are involved in a boundary line dispute, they're often surprised to learn that their legal boundary line and property line is not the same as the property line that's been used by them and their neighbors. Common way to resolve a boundary line dispute in Minnesota is called a quiet title action. And when you bring a quiet title action, you're essentially asking the court to confirm your ownership of a particular piece of property and to prevent any subsequent claims to that property. The common legal theory that we use in quiet title actions is called adverse possession. In Minnesota, to prove adverse possession, you or your predecessors in title must show 15 years of continuous, open, exclusive, hostile, and actual use. Now, if you can prove that, you will be judged to be the legal owner of that property, keeping in mind that government property and property that's previously been registered by the Torrance registration system can't be adversely possessed. Now, of course, bringing a quiet title action a lot more expensive and time consuming than simply resolving the property dispute out of court with your neighbors. So a lot of times these can be resolved with people as long as they respect their neighbors and keep good open communication with them.